policy. I am bound to indemnify the legal liability incurred by him. Incurred by whom? Not by the owner of the vehicle, but by the insured.
Specified in the policy.
Against any liability which may be incurred by him in respect of the death of or bodily injury to any
what
person.
are the persons specified in the policy? Whatever now you are reading, it says that against liability which may be incurred by him in respect of the death or bodily injury to any person, including the goods, etc. Insures the person or class of persons specified in the policy. Sorry, I was reading the reading one. You are referring to B specifically. 147B.
147 1 and B. Yes, madam. Yes, madam.
Insures the person or class of persons specified in the policy. Who are the persons specified in your policy?
Yes, my lord. Correct. Policy exhibit R1. It refers to insured. It is hereby declared and agreed that as from 27/8/2015, the interest in the policy is.
Vehicle and the policy was issued. Who was the owner of the vehicle and the policy was issued?
Second respondent who died during the.
He was the owner of the vehicle and the policy was issued. How did respondent number 1 become owner and when did he become owner?
My lord,
Number 1 was the RC owner.
Owner of the vehicle, is it your argument?
Policy ಕೊಡಿ ನೋಡೋಣ ಯಾರ ಹೆಸರಲ್ಲಿದೆ ಪಾಲಿಸಿ ಹೋಲ್ಡರ್ ಹೆಸರೇನಿದೆ ನೋಡೋಣ.
Policy is taken by a person who is not the RC owner.
No.
And the RC owner.
No, please. Here, listen to our question. Is it your case that you issued a policy in favor of a person who was not a owner of the vehicle? Person who was not a owner of the vehicle. Is that your case?
Well, this could be other way also.
No, please answer this question. Then we'll go to the next.
That's why we asked you to show the policy.
You can't take the plea.
Exhibit R1 is according to a policy. According to, is it a policy? Very endorsement anta ide.
Endorsement.
Endorsement schedule anta ide. Have you produced the policy?
Whose favor generally you issue the policy. If there is whose favor generally you issue the policy. If there is a change of ownership, what happens? That was the second circumstance. That is why we asked the first question. You're not answering that. Is it your case that you consciously issued a policy in favor of a person who is not a owner of the vehicle? Is that your case? Please answer that first. Then we'll come to the next question. You're not answering that. Normal circumstances, A could be owner of the vehicle in whose favor you issue the policy. Very next day he can sell the vehicle to somebody else. B can become the owner. Policy can continue in the name of the A. What is the consequence of that? Explain that. You put up something else in the hag heading.
See, in para 4 of your.
If it is waste of time, I will stop on it.
No.
If it is waste of time. In fact, I thought that.
No, please, we are asking you, please tell us. We will answer your question.
Milan, how can I say?
No, you are right. Mr. Counsel, please, one second. You are proposing an argument referring to section 146 and 147 that only we are answerable to the insurer and nobody else.
Insured.
Valid.
Insured.
Correct. Therefore, we are asking, is it your case that you have issued a policy in favor of a person who is not a owner of the vehicle? Please answer that fundamental question. We'll go later.
Yes,
There ends the matter.
My lord, this question, that is the reason
Which is why we told you, if it is not, we will be wasting our time. You don't take offense of that. If we are not answering that, academically also, we will be wasting our time. So don't take offense of that. Answer this fundamental question.
My lord, the requirement of law is that the both.
Please tell us the facts. Please tell us the facts.
My lord,
we are asking simple question. We are asking simple question. Please answer that. Then we'll proceed further.
Correct, Krishnaswamy. Look at para 4 of your written statement. They have said it is true that respondent has issued private car policy in respect of vehicle number so and so, the same
So and so.
vehicle, but the original copy of the policy is in the possession of and control of respondent number 2 and 3. Respondent number, you were respondent number 3, alva?
Original,
Respondent number 2 and 3. You are respondent number 3. Shriram General Insurance ತಾನೆ ನಿಮ್ದು?
original is with the owner. Only one
ನಿಮ್ಮ
copy.
written statement ಓದಿ. Para 4. It is true that this respondent para ಏನು but original is in the possession of respondent number 2 and 3 ಅಂತ ಹೇಳ್ತೀರಿ. 2 means the policy holder, 3 means you only. You have not produced the policy. This respondent calls upon respondent number 2 and to produce the original policy. You say it is in your possession also, but in ನಿಮ್ಮ ಕಾಪಿನೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಯಾವ್ದೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಿ. That is one thing. So if you are trying to say that you are liable to pay the risk of only the insured, then why do you insure the vehicle? You have insured the vehicle.
My lord, that in fact I will answer that
Risk
by
arising
reading.
out of use of the vehicle.
My lord, yes, my lord
Risk
is.
arising out of use of the vehicle.
My lord.
Statement ಓದಿ, ನಿಮ್ ಪಾಲಿಸಿ ಓದಿ ಅಂತ ಹೇಳಿದ್ವಿ. You have not produced the policy, certificate of policy. ಇಲ್ಲೊಂದು ಯಾವ್ದೋ ಇದೆ, ಅದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ. What it says? ಜೆರಾಕ್ಸ್ ಮಾರ್ಕ್ ಪ್ರೊಡ್ಯೂಸ್ ಆಗಿದೆ, ಮಾರ್ಕ್ ಆಗಿಲ್ಲ. ಮಾರ್ಕ್ ಆಗಿರೋದು ಯಾವುದು?
Exhibit
ಮಾರ್ಕ್
R.
ಆಗಿರೋದು ಯಾವ್ದೋ ಒಂದು ಶೆಡ್ಯೂಲ್ ಅಂತ ಮಾರ್ಕ್ ಆಗಿದೆ. It was produced by him.
My lord,
ಶ್ರೀರಾಮ್ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್. ವೆಹಿಕಲ್ ನಂಬರ್ ಎಷ್ಟು? ಟೊಯೋಟಾ ಇನ್ನೋವಾ ಅಲ್ಲ?
Toyota Innova.
AP 27 AD 3636.
AP
ಪಾಲಿಸಿ ಕಾಪಿ ಅಂತ ಒಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಮಾರ್ಕ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಅದು ಪಾಲಿಸಿ ಅಲ್ಲ, ಶೆಡ್ಯೂಲ್ ಅಷ್ಟೇ ಇದೆ ಅದ್ರಲ್ಲಿ.
ಅಲ್ಲ ಅವ್ರು ಮಾಡಿ
ಪಾಲಿಸಿ ಕಾಪಿ ಅಂತ ಆಗಿರೋದ್ರಲ್ಲಿ ಬರೀ ಪ್ಯಾಕೇಜ್ ಪಾಲಿಸಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಶೆಡ್ಯೂಲ್ ಅಂತ ಇದೆ. ಈವನ್ ಹಿಯರ್ ಆಲ್ಸೋ AP ಇದು AP 27 AD 3636 ಅನ್ನ you have insured the risk arising out of use of this vehicle.
My lord,
Not a risk of that particular person.
In fact, according to 147, my lord,
Risk specified ಏನಿರುತ್ತೆ ಅಲ್ಲಿ ಬೇರೆ ಮಾಡ್ಕೊಳ್ಳೋದಾದ್ರೆ
147(5) may kindly. One day. Because this provision is not even referred to in most of the cases. That is the reason
correct.
I require 147(5) also to be read along with 147(1).
There are so many cases where insurers take, some third person takes for the benefit of the registered owner.
My lord, this, as far as liability of insurer is concerned, insurer
ಅಲ್ಲಿ
or his
person specified ಅಂದ್ರೆ persons like third parties, driver, personal accident ಇರುತ್ತಲ್ಲ ಅದರದ್ದು. we don't think that it is
my lord, I read 147(5).
147(5).
Not 147 shall be liable to indemnify the person or classes of persons specified in the policy in respect of any liability which the policy purports to cover in the case of that person or those classes of persons. That is what it indicates.
Specified ಅಂತ ಹೇಳಿ risk of persons ಅಂದ್ರೆ ಯಾರು?
My lord,
Risk of third party, risk of the driver, risk of personal accident. ಸ್ಪೆಸಿಫೈಡ್ ಅಂದ್ರೆ ಯಾವುದು? ಅದಕ್ಕೆ ಪಾಲಿಸಿ ನಿಮ್ದು ನೀವು ಬರೀ ಶೆಡ್ಯೂಲ್ ಮಾತ್ರ ಹಾಕಿ ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. You have not produced the policy before the tribunal.
my lord,
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ನೀವು. ನೀವು ಅದನ್ನ ಮೊದಲು ನೋಡ್ಕೊಳ್ಳೋದಿಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನ. ಇಲ್ಲಿ ಬಂದು ನಿಂತಾಗ ನೋಡ್ಕೊಳ್ತೀರಾ. ಈಗ ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀರಿ. One policy copy, it seems they have produced that copy is not marked. ಅದು ಒಂದು ಅನ್ಮಾರ್ಕ್ಡ್ ಇದೆ ಇದರಲ್ಲಿ.
evidence also RW1.
They have let in the ಅಲ್ಲ ಅವರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲೇ ಕೇಸ್ ರೆಕಾರ್ಡ್ ಎಲ್ಲ just now we saw that there is one copy of the policy which is not marked.
person indicates the insured. My lord,
Then that we should say ridiculous. ಕೊಡಿ ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ?
person is insured and
Whose risk is insured?
risk of the insured is
ಸ್ಪೆಸಿಫೈಡ್
covered.
ಅಂತ ಇದೆ. ಅದರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಟೇಬಲ್ ಅಲ್ಲಿ ಒಂದ್ ಕಡೆ ಇರುತ್ತೆ ನೋಡಿ ಯಾರ್ಯಾರ್ದು ಅಂತ. ಪರ್ಸನಲ್ ಆಕ್ಸಿಡೆಂಟ್, ಡ್ರೈವರ್,
My lord, that is not
ಪ್ರೀಮಿಯಂ
the one. In fact,
ಆಯ್ತು ತೋರ್ಸಿ. ಅದ್ರ ಮೇಲೆ ನೀವು ಬರೀ ಪ್ರೊವಿಷನ್ ಓದೋರ್ಕಿಂತ ನೀವು ಹೇಳೋ ಪ್ರಕಾರ ಎಲ್ಲಾದ್ರೂ ಇಫ್ ಎನಿ ಲಾ ಇಸ್ ಲೇಡ್ ಡೌನ್ ಶೋಸ್ ಅದಿಲ್ಲ. ನೀವು ಕೊಟ್ಟಿರೋದು ಎಕ್ಸಿಬಿಟ್ R1 ಓನ್ಲಿ, ಇಟ್ ಇಸ್ ಎ ಶೆಡ್ಯೂಲ್.
my lord, could it be taken up after 5? My lord, could it be taken up after 5 minutes? My lord, I will go through these records and submit it.
ವಿಲ್ ಇಂಪೋಸ್ ಕಾಸ್ಟ್ ಅಂಡ್ ಅರ್ಜೆಂಟ್. ನೀವು ಓದೋದಿಲ್ಲ, ಓದ್ ಬದಲು ಬಂದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಕೋಬೇಕು. ಇಲ್ಲಿ ನಾವು ಕೇಳೋವಾಗ್ಲೇ ಮಾಡ್ತೀವಿ ಅಂತಂದ್ರೆ ಹೇಗೆ ಅದು?
Before commencement of argument ನಾನು ಕೇಳಿದೆ, ಒಂದು ಸ್ವಲ್ಪ ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ.
ಇಲ್ಲಿ ನೋಡೋದಲ್ಲ, ನೀವು ನೋಡೋದಿದ್ರೆ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ, ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಕುತ್ಕೊಂಡು ನೋಡ್ಕೋಬೇಕು. ಇಲ್ಲ ಅಂದ್ರೆ ಮೊದಲು and it is your document, where is the need of you seeing that?
In fact, I am handicapped.
And it is
I have rebuilt the case.
Very unfortunate that most of you here argue only reading, holding the judgment, impugned judgment in your hand. ಯಾವ ರೆಕಾರ್ಡ್ ಇಟ್ಕೊಂಡಿರೋದಿಲ್ಲ. As brother said, we spent now around 20 minutes time on this. And now we are seeking passover.
5 minutes.
ನಿಮ್ಮ ಹತ್ರ ಇತ್ತಾ ಪಾಲಿಸಿ ಕಾಪಿ? ನಿಮ್ಮ ಹತ್ರ ಏನಾದ್ರು ಇದೆಯಾ? ಅಲ್ಲಿದೆ ನೋಡಿ, ಅದ್ರಲ್ಲಿ ಒಂದು ನೀವು ಇದು ಮಾಡೋದಿಲ್ಲ. 2023 ಇಂದ ಇದೆ.
For final hearing, seal number 50, Government Advocate, Mayana PM Prakash.
Really pass over. AG
Who is appearing?
Kiran Ron. AG.
Oh. ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು?
Mayana PM.
My lord, I am for the respondent in both the matters. It is the government's appeal, my lord.
ಮೂರು ಮ್ಯಾಟ್ರ ಇದು. ಇನ್ನು ಇಷ್ಟೊತ್ತಿನ ಮೇಲೆ ಏನ್ರಿ 342 ಆಯ್ತು?
He's on Lexington quota number 7, my lordship.
ಎಸ್, ಏನ್ ಹೇಳ್ತೀರಾ? ನಿಮ್ಗೆ
I
ಅರ್ಜೆನ್ಸಿ
am ready, my lord.
ಇದ್ರಲ್ಲಿ ನಿಮ್ಗೆ ಯಾವ ಸಕ್ಸೀಡೆಡ್ ಬಿಫೋರ್?
Yes, my lord.
What is the decretal
Suit
amount?
is, no, my lord, one is suit for declaration and this one injunction.
1996 ದೈನಲ್ ಸೂಟ್.
ಹೌದು, ಅದು ಒಂದ್ಸತಿ ರಿಮಾಂಡ್ ಆಯ್ತು ಇಲ್ಲಿಂದ ಕೋರ್ಟ್ ಇಂದ.
Partly suit filed by the plaintiffs in so and so.
But suit for declaration was decreed earlier. And when it came up before this court, my lord, they produced a notification of 1904.
Now what is this money recovery ಅಂತ ತೋರಿಸಿದಾರಲ್ಲ?
Money recovery, they have filed a suit for recovery of money from me on the ground that I have removed the excess timbers without the authority.
Oh, that was 121 of 2000.
Yes, 12 of 2000, yes.
12. Their suit is dismissed.
Their suit is dismissed, my suit is.
So anyway, now it should be urgent for them only.
Yes.
Declaration, that is snake.
Their only case is because of notification of 1904, I don't have the ownership over the property. I purchased this property in 90.
Their suit for money recovery is dismissed.
Yes.
It should be urgent for them.
Yeah, I agree.
Because you are safe now. Your declaration also,
Yes,
possession,
yes.
according to possession is with you.
With me.
Government has adjourned at the request of learned HCP. ಆಯ್ತಲ್ಲ, 5 minutes ಅವ್ರದ್ದು ತಗೊಳ್ಳಿ. ಕೃಷ್ಣಸ್ವಾಮಿ ಅವ್ರದ್ದು 5 minutes ಆಯ್ತಲ್ಲ, ತಗೊಳ್ಳಿ.
For final disposal, seal number 49.
ಇಲ್ಲ ಶೆಡ್ಯೂಲ್ ಇದೆ ಅದೇ.
TCS ಕೊಡಿ. TCS.
This is an endorsement schedule, not policy.
You mark ಮಾಡ್ಸಿರೋದೇ ಅದನ್ನ. You have not got marked the policy, then how can you argue all these things? You have clearly admitted in your written statement that you have
There is a
issued the
policy.
policy.
Alla, policy of insurance is.
Ah.
Sir, transfer of.
MV Act. The petition prove that disease circumstances so rash and negligent driving, whether the petitioners are entitled for compensation. If
Correct.
so,
Show us from your
how much
written.
and from whom?
You have the copy of your written statement.
Yes,
ಇದೇನು ಹೇಳಿದ್ರಲ್ಲ ನೀವು, policy was issued to so and so, it covers only risk arising of that and not owner's risk ಅಂತ ಹೇಳಿದ್ದೀರಾ. Exhibit R12 ಅಂದ್ರಲ್ಲ ಇದೆ. ಅಲ್ಲ R12 ಅನ್ನೋದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಬ್ರದರ್, R1 ಒಂದೇ ಮಾರ್ಕ್ ಆಗಿಲ್ಲ. ಇದ್ರೆ it should be there, ಅವ್ರು ತಪ್ಪಾಗಿ ಹೇಳಿದ್ರೆ.
well, it is further submitted that the liability, if any, of this respondent is limited to the terms and conditions of the policy
What is
of
what
insurance
is the
issued, which is in
exhibit R1?
accordance with the provisions of motor.
Please read exhibit R1. Who has issued it? Please read exhibit R1. ತಗೊಳ್ಳಿ. Read R1, issued by your company.
Yes, ma'am. Yes, ma'am.
ಅವ್ರನ್ನ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
It is an endorsement, not a policy.
ಎಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅದನ್ನ ಅವರು?
It is an endorsement issue.
What is the effect of that? You are going, you are not,
ಮುನಿರತ್ನಂ, insured name ಮುನಿರತ್ನಂ. Okay, ಮುನಿ ಚಂದ್ರಯ್ಯ. Insured name ಇದು ಅಡ್ರೆಸ್ ಅಲ್ಲ, ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, that he exists.
Issued's name is Vadus Palli Muniratnam.
As from 27%, the interest in the policy is transferred to and vested in ಅವ್ರಿಗೆ ಬಂತು ಅಂತ. ಅದು ಸಪಲ್ಲಿ ಮುನಿರತ್ನಂ of AP. He was respond number 2. Carrying on engaged in the business of professional. ಅವನ ಇನ್ಶೂರ್ಡ್ ಹೆಸರು ಇದು ಒಂದೇ. But where is the statement that it does not cover his risk ಅಂತ ಹೇಳಿ?
they cannot go against it.
Present owner. Respond number 2. Respond number 2 is not the registered owner. Registered owner is.
So, Muniratnam AP.
ಹೌದು, ಮುನಿರತ್ನಂ AP is respond number 3. Respond number 2. Policy stands in his name. Registered owner is he. But even otherwise, they issue the policy to cover the risk of use of a vehicle. ಈಗ ನಿಮ್ಮ ನನ್ನ ಬೆಳಕಿಗೆ ನೀವು ಒಂದು ಪಾಲಿಸಿ ತಗೋಬಹುದು, ನಾನು ಓನರ್ ರಿಜಿಸ್ಟರ್ಡ್ ಓನರ್ ಮಾಡಿರ್ತೀನಿ, ಬಟ್ ನೀವು ತಗೊಂಡಿದ್ದೀರ ಅಂತ ನನ್ನ ವೆಹಿಕಲ್ ರಿಸ್ಕ್ ಅವ್ರು ಕವರ್ ಮಾಡೋದಿಲ್ಲ ಅನ್ನೋಕ್ಕಾಗಲ್ಲ. ಅವ್ರು ಕೊಡ್ತಾರಲ್ಲ ಬಿಸ್ನೆಸ್ ಮಾಡೋದಕ್ಕೆ, ಬೇರೆ ಯಾರಿಗಾದ್ರೂ ಕೊಡ್ತಾರೆ. ನೀವು ಸತ್ತಿಲ್ಲ ಅಂತ ನಿಮ್ಗೆ ನೀವು ಸತ್ತಿಲ್ಲ ಅಂತ ಬೆಲೆ ಕೊಡೋಕ್ಕಾಗೋದಿಲ್ಲ ಅಂತ ನಿಮಗೆ ಸರಿ, ದಟ್ ಈಸ್ ಇನ್ಕರೆಕ್ಟ್. ಅಲ್ಲಿ ಎಸ್
The Motor Accident Claims Tribunal, while dealing with this aspect, with regard to the liability, my lords may kindly notice that it holds para 53 judgment, para 53 of the judgment of MAC.
Yes, para 53 of the judgment.
Para 53 of the judgment.
Yes.
From going through the complaint and charge sheet, it is clear that on the date of accident, the deceased along with other court staff was proceeding to attend a housewarming ceremony of a judicial officer, and in the complaint itself it is mentioned that the Innova car was owned by a friend by name Muniratna, was taken and they have hired Dinesh Kumar, the driver, to drive the vehicle. From the above said government city that to attend the housewarming ceremony of superintendent official officer, the staff have decided to go in a vehicle by using so and so furnished. Therefore, it can be, my lord, this is where they contend Muniratna was the owner. And they had taken the vehicle from him because he was a friend. And they provisions of MBI.
Read that. 146, please read 146.
147, my lord. As
Read.
far as liability is 147.
Where's the prohibition that such arrangement should not be there?
See, we gave one example for that, just where it is. See, if A takes a life insurance policy in the name of B, if B dies, whether the insurance company can say that A had taken the policy, therefore will not pay for the LRs of that insured.
My lord,
What is insured
my
is,
lord, the similar question was posed to me in one seminar where the question was, you issue a policy in respect of one person, particular person. Why, how insurer could be made liable to pay compensation,
Sir,
if vehicle
146
is not driven by him?
146 language is very clear. I can allow anybody to use the vehicle provided the vehicle is validly insured. That's all. Please read 146.
My lord, prohibition,
146.
my lord, prohibition.
No, no, no.
Sir, please read
and then your
146.
persons
My lord.
specified under the you are not produced the policy, but Xerox copy of a policy is there. We do not know why it was not marked. Same vehicle, the policy. Ali, schedule premium anta iruttalla, liability, B, ali, B liability, basic TP cover, third party cover. Additional law, PA for owner, driver.
Owner driver,
Huh.
owner come driver. That is-
Owner driver, third party. See, I submit that for the time of alleged incident, the car has been used for commercial purpose, hire and reward, same is violation of policy. Hence, it is willful breach of policy condition by the insured. Therefore, this respondent is not liable to pay any compensation and petition against this respondent is liable to be dismissed. I further submit that petitioner 1 and 2 are already married. ಅದೆಲ್ಲ ಬೇರೆ ಪಾಯಿಂಟ್ ಮೇಲೆ ನಿಮ್ಮ ವಿಟ್ನೆಸ್ ಡಿಪೋಷನ್ ಓದಿ ಇಷ್ಟೇ ಪ್ಯಾರಾ 3 ಆಫ್ ದ ಡಿಪೋಷನ್ ಅಲ್ಲಿ ಇದನ್ನ ಒಂದೇ ಹೇಳಿರೋದು ಪಾಲಿಸಿ ಇಶ್ಯೂ ಮಾಡಿದ್ದೇನೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಪ್ಯಾರಾ 3 ಆಫ್ ದ ಡಿಪೋಷನ್ ಅಲ್ಲಿ ಈ ತರ ಇಟ್ ಹ್ಯಾಡ್ ಕವರ್ಡ್ ದ ರಿಸ್ಕ್ ಆಫ್ ದ ಓನ್ಲಿ ಪಾಲಿಸಿ ಹೋಲ್ಡರ್ ನಾಟ್ ದ RC ಓನರ್ ಆರ್ ದ ಪರ್ಸನ್ಸ್ whose risk was covered or the liability ಇದೆ ಅಲ್ಲ. What is the meaning of liability?
ಅಲ್ಲ, deposition ಇದೆ.
See, there
Deposition
should
is
be some
available.
foundation for this.
Madam, deposition
Business
is
Swami ಅವರೇ,
available.
ಈಗ ನೀವೇನೆಲ್ಲ ಹೇಳೋದಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದೀರೋ ಅದಕ್ಕೆ there should be some foundation before the tribunal. ಏನು ಇಲ್ಲದೆ ಇಲ್ಲೇ ಹೊಸದಾಗಿ ಹೇಳಕ್ ಶುರು ಮಾಡಿದ್ರೆ ಹೇಗೆ ಎಲ್ಲಾನು? And this is my father.
3 months after my marriage, my father expired. For
Karnataka.
45 days, I stayed in matrimonial home. Incorrect to suggest that I was not dependent on my father.
ಅಲ್ಲ ಅದೆಲ್ಲ
I studied
ಡಿಪೆಂಡೆನ್ಸಿ ಬಗ್ಗೆ ಆಯ್ತು. ಈಗ ನೀವೇನ್ ಪಾಯಿಂಟ್ ಪ್ರಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅದ್ರ ಮೇಲೆ ಎಲ್ಲಾದ್ರೂ ಎನಿ ವಿಸ್ಪರ್ ಇನ್ ದ ಐದರ್ ಇನ್ ದ ಪ್ಲೀಡಿಂಗ್ಸ್ ಆರ್ ಇನ್ ದ ಡಿಪೋಷನ್ಸ್? ಎಲ್ಲೂ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಓದಿ ಎಲ್ಲೂ ಇಲ್ಲ, ಈ ಪಾಯಿಂಟ್ ಎಲ್ಲೂ ರೈಸ್ ಮಾಡಿಲ್ಲ. ಎಸ್ ಹೇಳಿ, ಮುಂದಿನ ಹೇಳಿ. ಕಮ್ ಟು
the next point would be, if my lords are not inclined to appreciate this point, the next point would be.
appreciate ಅಲ್ಲ,
To
you
some
cannot for the first time become the
I was under the impression that a legal point could be.
respondent or you cannot step into their shoes and leave give evidence here. Yes.
The second point would be whether the claimants who are daughters can.
Daughters are
Virendra Kumar, settle position. You are aware of all this. You are a senior person. Virendra Kumar, judgment is clear. Again, you want to put the question again?
Which, my lord,
Sorry, mother. Judgment ಕೊಡಿ ಅವ್ರಿಗೆ.
ಯಾವ್ದು? My lord,
LRs can file the petition ಅಂತ ಏನೋ ಒಂದಿದೆ ಅದು.
legal representatives can certainly file a claim petition.
ಹ್ಮ್.
In Lakshmi Kumar's case, this honorable court division bench also held, they can file. But
Dependency
dependency
need,
would be looked into.
question of dependency need not be gone into. Settle position of law.
ಕೊಡಿ.
ಕೊಡಮ್ಮ judgment ಕೊಡಮ್ಮ ಅವ್ರಿಗೆ. Para 15 ಕೊಡಮ್ಮ. 15 ಕೊಡಮ್ಮ.
ಅವ್ರ ಹತ್ರ ತಂದಿದ್ದಾರೆ ಕಾಪಿ.
ಹಾ, ತಂದಿದ್ದೀನಿ.
ಅವ್ರಿಗೆ ಕೊಡಿ. They were unmarried daughters.
Both are,
Wife of
in
married.
fact, one is married.
Married. ಹಾ. ಅದರಲ್ಲೇನೋ matrimonial
Married,
dispute ಇದೆ.
and,
Matrimonial dispute ಏನಿದೆ.
Married, your lordship. One is married. After 15 days, marriage were dissolved and mother is died and reverts to the father's house.
This is a subsequent judgment. Seema Rani. This court in so had.
Liability to pay the
major-
compensation under the
major
act does
married
not
and-
cease because of the absence of dependency. ಕೊಡಿ para 14 ಕೊಡಿ. On settle
Major
position of
married and
law.
earning sons of the deceased,
ಕೊಡಿ.
being legal representative, have a right to for compensation. Fully dependent or deceased or not?
Even major married and earning
His
sons of
sons in that
deceased
case were
would be covered by the expression legal representative of the
are
deceased.
largely dependent on the
Criminal
earnings.
has bounden duty
So
to
we have
consider
to,
their application irrespective. In fact, it has to consider because
In that case where earning merely 1,50,000 per annum, they were largely dependent on the earnings of the deceased and were staying with her.
my lord, this is Virendra's case of the Supreme Court. My lord, here in that particular Virendra's case, she was a government
So
employee.
you have to.
She was a government employee.
Only ಈ case
She-
ಅಲ್ಲಿ
mother
ತೋರ್ಸಿ,
died.
what was the income of these two claimants? What was the income of these two claimants? Anything is there on record
Yes,
to show
ma'am.
that?
Yes,
ಹಾ.
yes, ma'am.
ತೋರ್ಸಿ, ಅದನ್ನ ತೋರ್ಸಿದ್ರೆ.
Cross examination. Hindu Chip.
Fiction file ಮಾಡೋದಕ್ಕೆ there is no bar.
My lord, Virendra's case,
Would still be covered under the legal representatives ಆಗ್ತಾರೆ. This court in Muniraj's case had expounded that liability to pay compensation act does not cease because the absence of dependence of the concerned legal representative. Noted
Approved in this case.
expression legal representative has not been defined. ಇಲ್ಲ ನಮ್ದು ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನಮ್ದು. ಇದು ಹಿಂದಿನ ಕೇಸ್ ಯಾವ್ದು? 2007 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 1474 ತೆಗೆದುಕೊಡಿ. 2000 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 1474. Yes, you can argue further. We'll see that.
my lord, as far as Virendra's case is.
ಅದು ಬಿಟ್ಬಿಡಿ ಜಡ್ಜ್ಮೆಂಟ್, ಇದ್ರಲ್ಲಿ ಅವ್ರಿಗೆ ಏನ್ ಡಿಪೆಂಡೆನ್ಸಿ
my
ಇದೆ
lord,
ಅಂತ ಅವ್ರಿಗೆ ಏನ್
my lord,
ಇನ್ಕಮ್ ಇತ್ತು ಅಂತ
Cross examination of people.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ PW1.
Yes.
ಏನ್ ಹೇಳಿದ್ದಾರೆ?
The deceased Ramesh Babu is my father. My mother is not alive. She died after 3 months of peace.
ಒಂದ್ ನಿಮಿಷ ರೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಏನಾದ್ರು ನಾನು ಹೇಳಿದೀನಿ ಲಾಸ್ಟ್ ಟೈಮ್ ತೋರಿಸಿದಾಗ there is no
Para 15 ಓದಿ, now the law is settled.
ಅಲ್ಲ ದೇ ಕ್ಯಾನ್ ಫೈಲ್ ದ ಪಿಟಿಷನ್ ಅಂತ ಇದೆ ಕಂಪಲ್ಷನ್. ಓದೋಣ ಸಮಾಧಾನ ದ ಎವಿಡೆನ್ಸ್ ಅದಕ್ಕೆ ಅದು ಮನ ಒಳಗನ್ಸ್ ಕೇಸ್ ಕೊಡಿ. ದೇ ಕ್ಯಾನ್ ಫೈಲ್, ಸಟನ್ಲಿ ದೇ ಕ್ಯಾನ್ ಫೈಲ್.
Filing, ಇದು ನೋಡಿ. Tribunal application irrespective of the fact whether the
ಅಪ್ಲಿಕೇಶನ್
concerned legal representative was fully dependent on the deceased or not.
ಇದು
Limit of claim toward the convention is ಬೇಕಾಗಿಲ್ಲ. You have to go ahead.
ಕನ್ವೆನ್ಷನಲ್ ಹೆಡ್ ಮೇಲೆ ಅಂತೂ ಇಲ್ಲ, ಕನ್ವೆನ್ಷನಲ್ ಹೆಡ್ಸ್ ಅಲ್ಲಂತೂ ಕ್ವಶನೇ ಇಲ್ಲ, ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡೋದು. ಆದ್ರೆ ಡಿಪೆಂಡೆನ್ಸಿ ಮೇಲೆ ಹೇಳುವಾಗ ಮನವಳಗನ್ಸ್ ಕೇಸಲ್ಲಿ ಏನು ಹೇಳಿದ್ರೆ ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ಬೋತ್ ಆರ್ ವರ್ಕಿಂಗ್, ಹಸ್ಬೆಂಡ್ ವೈಫ್ ಹಸ್ಬೆಂಡ್ ಪಿಟಿಷನ್. ಅವಾಗ ಏನು ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ವರ್ಕ್ ಮಾಡ್ತಿದ್ರು ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ, ಬಟ್ ದರ್ ಇಸ್ ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಬಿಕಾಸ್ ವಾಟ್ ಎವರ್ ಶಿ ವಾಸ್ ಅರ್ನಿಂಗ್ ಅಂಡ್ ಸೇವಿಂಗ್ ಇಟ್ ವಾಸ್ ಫಾರ್ ದ ಬೆನಿಫಿಟ್ ಆಫ್ ದೋಸ್. He loses at least to that extent ಅಂತ ಹೇಳಿ ಅದ್ರ ಮೇಲೆ ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಎಲ್ಲ ತೆಗಿತಾರೆ. ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಪಾರ್ಟ್ ಆಫ್ ಇಟ್ ಅಂತ ಅಂದ್ರೆ ಹಾಫ್ ಆಫ್ ಇಟ್ ಇಫ್ ದೇ ಆರ್ ಲಿವಿಂಗ್ ಸಪ್ರೇಟ್ಲಿ ಆರ್ ಇಫ್ ದೇ ಆರ್ ಲಿವಿಂಗ್ ಟುಗೆದರ್ 3/4 ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ. ಎಸ್ ಅದು ಕೊಡಿ ಅರ್ಜುನ್. ಏನ್ ಹೇಳಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
Cross examination ಅಲ್ಲಿ my lord, after 6th line they were going to Kurnool for a housewarming ceremony. It is false to suggest that my father and others have hired the Innova car on the date of accident. Myself and my elder sister are the only children. In 2015, my husband has filed a matrimonial petition against me of marriage, and its number is so and so. My husband works in a college as a professor. I do not know his monthly salary. I had sought for interim maintenance in the said case, but it was rejected, and I do not know the reason for its rejection. Before this, that there is a
We have noted your submission further.
that there is a
We have noted your submission further. Yes. Yes.
Produce the documentary evidence to show she has already produce the documentary evidence to show she has already dissolved the marriage and come back to the house.
Yes.
It is false to suggest that I have not spent 25,000 towards transportation of dead body.
The conventional heads fix agbiಟ್ಟಿದೆಯಲ್ಲ.
What I submit is
Your point is that they were working or they were married, therefore they cannot be treated as dependents. Simple. This is a submission. Yes.
my lord, as against deceased. If this honorable court wants, that can reasonably say that it should be more than 1/3 as per reductions. Personal deductions. I will never say that they are not entitled for compensation. That is not entitled for compensation. That is not, my lords may have to decide it. Not at 1/3. May have to decide it. Not at 1/3. My lord, one more mistake is committed. 10% should have been. What I submit is loss to estate. That is whatever that he was saving should be the basis. And Manavalgan's case is also available. That should be the basis to grant law.
Yes.
One more submission as far as the dependency. The other one lady is married and she is living with her other. As far as other claimant is concerned, they want to produce some documents. My lord, one thing they have admitted that their application for grant of maintenance is also rejected. The reason she is also not, and they have not been by her husband. Both there is a dissolution of marriage, they will get
Even if there was no dissolution, even if there is a married daughter, now why Section 6 of Hindu Succession Act has come in the statute? See, these old arguments, you should be little enlightened or sensitized on those matters. Why the daughter becomes when alienated from the relationship, the daughter gets
168
Mr.
banded
Mr. Swami,
just compensation.
whether daughters gets alienated from the family, from the relationship.
They will not get alienated. They are entitled to
We
get all
have heard you.
benefits.
Yes. Next. ನಿಮ್ದೇನಿತ್ತು?
Regarding policy, your lordship.
ಇಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅವ್ರು ಇದ್ರಲ್ಲಿ ಏನಾಗಿರುತ್ತೆ? Go by the facts.
ಹೇಳೋದು ಬೇಡ.
ಅಲ್ಲ ಸರಿ ಪೊಸಿಷನ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಅವ್ರು ಕೈಗೆ ರಿಜೆಕ್ಟ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಂದ್ರೆ ಇನ್ನೊಂದು ಈಗ ರಿಸಲ್ಟ್ ಈಗ ಒಂದು ಕೊಟ್ರಲ್ಲ, ಅದರಲ್ಲಿ ಡಿಪೆಂಡೆನ್ಸಿ ಮೇಲೆ ಮಟೀರಿಯಲ್ ಏನಿದೆ ಅದನ್ನ ನೋಡ್ಬೇಕಂತ. ಇದ್ರಲ್ಲಿ ಯಾವುದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಇದರಲ್ಲಿ ಎಲ್ಲ ಆಗಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ನೋಡಿದ್ರೆ ಅದರಲ್ಲಿ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ 2007 ಆದ್ಮೇಲೆ ಇಲ್ಲಿ ಕೊಟ್ರಲ್ಲ, ಈಗ ಅದಾದ್ಮೇಲೆ ಇಲ್ಲೇನಂತ ಮುಂದಿನ court went on to conclude extension for they were largely dependent on the earnings of the deceased. So ಅವ್ರದ್ದು ಎಷ್ಟಿರುತ್ತೆ ಅಂತ ನೋಡ್ಬೇಕು. ಡಿಪೆಂಡೆನ್ಸಿ ಬರೀ ಅವ್ರು ಎಂಪ್ಲಾಯ್ಡ್ ಇದ್ರೂ ಬರೋದು, ನಾಟ್ ಡಿಪೆಂಡೆಂಟ್ ಅಂತ ಹೇಳಕ್ ಆಗೋದೇನ. ಅವ್ರು ವೆದರ್ ದೇ ವರ್ ಡಿಪೆಂಡೆಂಟ್ ಆನ್ ದ ಇನ್ಕಮ್ ಆಫ್ ದ ಡಿಸೀಸ್ಡ್. ಮದುವೆ ಆದ ತಕ್ಷಣ ಇನ್ನೊಂದಕ್ಕೂ ಅವ್ರಿಗೆ ಡಿಪೆಂಡೆನ್ಸಿ ಹೋಗೋದ್ರೆ ಇಲ್ಲೇನು ಹೇಳಿದ್ದಾರೆ, ಪಿಟಿಷನ್ ಕೆನಾಟ್ ಬಿ ರಿಸೆಪ್ಟೆಡ್ ಆನ್ ದಟ್ ಗ್ರೌಂಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಕಾಂಪನ್ಸೇಷನ್ ಎಂಟೈಟಲ್ ಟು ಕಾಂಪನ್ಸೇಷನ್ such as person who will represent the estate of the deceased. Includes persons who included with the estate of the deceased and their properties was also.
Madam, on decision.
A legal representative is
Timber
one
credit.
who suffers on account of death
Madam, no
due to a motor
MFA
vehicle
77
accident
of 2004.
and need not necessarily be a wife, husband, parent, or child. ಈ ಕೇಸಲ್ಲಿ ಬೇರೆ ಇರ್ತಾರೆ. Daughter-in-law ಯಾರೋ ಇರ್ತಾರೆ. The right to file application has to be considered in the background of right to entitlement while assessing the quantum. The multiplier system is applied because the deprivation of the dependency. In other words, multiplier is a measure. Liability in terms of section 140, however, does not cease because of the absence of dependency. Therefore, even if there is no loss of dependency, the claimant, if he or she is legal representative, will be entitled to compensation.
My lord has also passed a judgment following.
ಅದೇ one for one ಒಳಗನ್ follow ಮಾಡಿ
Follow ಮಾಡಿ, my lord is passed in MF
Correct. But total
77.
dependency does. First thing you have to prove that they were not dependent.
As per my appeal is concerned, Your Lordship, 15% is added as per the. When I
What
say
was his age?
is 54.
59.
Age 54, permanently employed, ಅಲ್ಲ?
Finding given is 59.
Tell you that Aadhaar card is looking. His Aadhaar card also produced that shows 54 years.
Tribunal ಅವರು ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 59 ತಗೊಂಡಿದ್ದಾರೆ. Is that correct?
59, 58 ಅಂತ ಆಗಿದೆ.
58. ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ತಗೊಂಡಿದ್ದಾರೆ? Aadhaar card is exhibit.
Tell me, ಇದು one minute. Judgment. Document.
ಸರ್ವಿಸ್ ನಲ್ಲಿ ಇದ್ದವರು ಅಂದ್ರೆ ಏನಾದ್ರು ಪ್ಯಾನ್ ಕಾರ್ಡ್.
Pan card.
PW2 in his evidence has reports that deceased was aged 58. ನಿಮ್ಮ ವಿಟ್ನೆಸ್ ಹೇಳಿದಾರಂತಲ್ಲ 57 years, which is supported by the date of birth mentioned in exhibit P13 PAN card. His date of birth was 5/1/1958. So 57 years ತಗೊಂಡಿದ್ದು ಕರೆಕ್ಟ್ ಇದೆ.
7,000.
77,000.
959.
950. Based on what?
Tell me,
Para 37.
The deceased had two dependents.
Yes.
There was no tax of income for it.
Para 40.
Gross salary
Gross
was
pay,
77,759
759.
as per the revised pay scales.
Exhibit P.
Document ಯಾವ್ದು?
Exhibit P6.
Income tax returns last submit ಮಾಡಿದ್ದು ಅದನ್ನು ಕನ್ಸಿಡರ್.
What deductions ಇದೆ sir?
8,07,776 is considered as
ಹಾಕಿದ್ದೀರಾ?
43 ನಲ್ಲಿ.
It returns
50% is.
ಹಾಕಿದ್ದೀರಾ? ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? Instead of salary ಅದನ್ನು ತಗೊಂಡ್ಬಿಟ್ರೆ ಆಗುತ್ತಲ್ಲ. Charge sheet, deposition, salary certificate. No, income tax returns ಹಾಕ್ಸಿಲ್ಲ, ಅದಕ್ಕೆ ಅವರು ಹಾಕ್ತಗೊಂಡಿದ್ದು.
Para 43. Deduction.
Exhibit P6 is the salary certificate.
Salary certificate.
P6 ಪ್ರಕಾರ what is his salary?
77,759.
ಅದು ಗ್ರಾಸ್ ಸ್ಯಾಲರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. P6 ಅಲ್ಲ? ಆಗಸ್ಟ್ ಆಗಿ ಬರುತ್ತೆ 77,000. ಆಗಸ್ಟ್ ಆಗಿ ಬರುತ್ತೆ 77,759.
759.
759. 759ಗೆ 15%.
15%.
11,663.85.
ಎಷ್ಟು?
11,663.85.
0.8 ಅಂದ್ರೆ ಅದನ್ನ 669 ಮಾಡಬೇಕು. 664 ಮಾಡಬೇಕು. 0.8 ಅಂದ್ರಲ್ಲ. ಎರಡು ಸೇರಿದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ? 77,759.
89,423.
89,423 into really either we have to deduct here or afterwards we have to deduct. ಎರಡು ಮಾಡಿದ್ಮೇಲೆ annually ಮಾಡ್ಕೊಂಡ್ರೂ ಆಗುತ್ತೆ. into 12 ಮಾಡಿದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ?
10,73,076.
10,73,076.
076.
ಇದರಲ್ಲಿ ಅವಾಗ 2000 ಯಾವ್ದಿದೆ ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್?
15.
2015 ಅದು ಫೈನಾನ್ಸ್ ಆಕ್ಟ್ ಹೇಳಿದ್ರಲ್ಲಿ 2015 10,73,000 about 10 lakhs 1,25,000 ಫಸ್ಟ್ 10 lakhs ವರೆಗೂ 1,25,000 ಬ್ಯಾಲೆನ್ಸ್ ಎಷ್ಟು 73,000 76ಗೆ 30%. 30% of 73,076 ಎಷ್ಟಾಗುತ್ತೆ?
21,922.8.
21,922.8
922.8.
ಅಂದ್ರೆ 923 ಮಾಡಬೇಕು. ಇವಾಗ 1,25,000 ಪ್ಲಸ್ 21,923 ಎಷ್ಟಾಗುತ್ತೆ?
1,46,000.
1,46,923.
923.
ಈ 10,73,076 ಅಲ್ಲಿ ಮೈನಸ್ 1,46,923 ಮಾಡಿ
9,26,153.
26,000
9,26,153.
153 ಇದರದ್ದು 1/3 ಅಲ್ಲ ಡಿಡಕ್ಷನ್ ಇಬ್ಬರಿದ್ದಾರೆ 1/3 ಅಂದ್ರೆ 2/3 ಎಷ್ಟಾಗುತ್ತೆ ಇದರದ್ದು?
ನಾನು ಮೈ ಅದ್ರಲ್ಲಿ
70,435.
6 lakh
1,435.
para 13 and 14 of my lord.
35
They are living together 25% ಮಾಡಿ.
ಮಲ್ಟಿಪ್ಲೈಯರ್ ಎಷ್ಟು ಅದು ಗೊತ್ತಿದೆ ನಿಮ್ಗೆ? ಮಲ್ಟಿಪ್ಲೈಯರ್
9 ಆಗುತ್ತೆ ಇದರಲ್ಲಿ 9
9.
would be limit.
9 is the multiplier.
16,435 into 9
55,56,000.
55 lakhs 56,000
915.
915 ಇಬ್ಬರಿಗೂ 40 ಇಲ್ಲಿವರೆಗೂ ಎಷ್ಟು ರಿಲೀಸ್ ಆಗಿಲ್ವಲ್ಲ?
ಇಲ್ಲ ಏನು ರಿಲೀಸ್ ಆಗಿಲ್ಲ.
ರಿವಿಷನ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅವಾಗ.
ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ 15 ಕೊಟ್ಟಿಯಾರ ಅದು
ಅಲ್ಲ
ಜಾಸ್ತಿ ಆಗಬೇಕು. ಈ 3,000 and Filal was also 40,000 43 ಆಗುತ್ತೆ.
2015 ಇಂದ 10 ವರ್ಷ ಆಯ್ತು 3 ರಿವಿಷನ್ ಆಗುತ್ತೆ 52,000 ಆಗುತ್ತಲ್ಲ 52,000 into 2 ಆಗುತ್ತೆ
1,04,000.
1,04,000 ಸಿಮಿಲರ್ಲಿ ಅದು 39,000 ಆಗುತ್ತಾ? ಎಷ್ಟು?
56,99,915.
56,99,915 ಅವಾರ್ಡ್ ಆಗಿರೋದು ಎಷ್ಟಿದೆ?
49,14,650.
7,85,265.
49,14,650 enhancement to
85,265.
265
Only one point. Now I may request my lords. Admittedly, it is my lord's judgment.
We are aware of this question.
One second point
You
is
first you have to show that they were dependent, not dependent. Case ಮೇಲೆ rely again on. We are also not saying that the petition should be dismissed in its entirety. But dependency, if dependency is shown, then the amount has to be awarded. ಇಲ್ಲಿ ಅವರಿಬ್ರು ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ? ಒನ್ ಹ್ಯಾಸ್ ಲೆಫ್ಟ್ ದ ಜಾಬ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು. ಶಿ ಇಸ್ ನಾಟ್ ಇನ್ ಸರ್ವಿಸ್ ಅಂತ. ಅದು ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಆಗಿತ್ತು ಅಂತ ನೀವೇನು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಲ್ಲ? ವೈ ಇಟ್ ವಾಸ್ ರಿಜೆಕ್ಟೆಡ್ ಹರ್ ಮೇಂಟೆನೆನ್ಸ್ ಪಿಟಿಷನ್?
Amount in
Or you could have
deposit.
summoned some, if you had any information. Moreover, you read your deposition, your own evidence, your own deposition, whether these points were urged there. These appeals arise out of.
Yes, 758.
my lord, one more point is strict rules of pleadings and evidence not applicable in view of decisions rendered by the applicants.
Arise out of the judgment and award in MS number 839 of 2018. Past 5, the Chief Judge Court of Small Causes and member principal MACT, Bengaluru. First appeal ಯಾರ್ದಿದ್ರಲ್ಲಿ? ಯಾವ appeal ಅಲ್ಲಿ ಯಾವ್ದು ಕನೆಕ್ಟ್ ಆಗಿದೆ? 2092 is insurance company ಅಲ್ವಾ? The appellant was respondent number 3. Respondents the appellant in MFA number ಅಂತ ಮಾಡ್ಕೊಂಡು
ಅಕಲ್ತಾಕಿ.
ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರದ್ದು ಎರಡನೇದ್ರಲ್ಲಿ ಹೇಳಬೇಕು. ಇಲ್ಲ
ಅದು both the cases are.
appellant in MFA number 2092 was the third respondent. Response 1 and 2 were claimants 1 and 2. Respondent 3 and one aforesaid was ಅದನ್ನು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. Where respondents 1 and 2 in MVC number 839 of 2018 for the purpose of convenience the parties are referred to henceforth according to their ranks before the tribunal. The appellants, the claimants are the married daughters of deceased C. Ramesh Babu on
155 ಒಂದು ಸ್ವಲ್ಪ ಮಾಡಿಕೊಟ್ಟಿದ್ದೆ.
on 7/8/2015 at about 2 a.m. when Ramesh Babu was traveling in near Vattalapalli, Mandala, in Innova car bearing registration number AP27 AD 3636. The said car met with an accident.
ಬೆಳಿಗ್ಗೆ ಹಾಕ್ಬೇಕು ಮತ್ತೆ ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟು ಬೆಳಿಗ್ಗೆ ಹಾಕ್ಬೇಕು ಮತ್ತೆ ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟು
Met with an accident. Ramesh Babu succumbed to the accidental injuries. Regarding the accident,
ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿ
regarding the accident, on the basis of complaint as per Exhibit P2, Vattalapalli police, Vattalapalli police registered FIR against the driver of the said car, Vattalapalli police station, in crime number 101 of 2015 of their police station for the offences punishable under section 337 304 APC. On investigation, the charge sheet as per Exhibit P of the car, respondent 2 had taken insurance for the said car from and the said policy was issued by respondent number 3 in respect of the said car. The claimants filed MVC number 839 of 2018 containing that the accident and death of Ramesh Babu occurred due to actionable negligence on the part of the driver of the aforesaid car. They further contended that they were that deceased was working superintendent. Which court he was working? Salary certificate Exhibit P. Superintendent ಅಂತ ಇಲ್ಲ post. Madanapalli ಆನ್ಲೈನರ್ ಆಗಿರಬಹುದು. At the time of the accident, Ramesh Babu was working as superintendent in the court of principal junior civil justice court,
CH-1 principal court.
Madanapalli, and earning rupees 77,759 per month. They were dependent on his income. They further contended that due to the death of Ramesh Babu, they have suffered financial and emotional damages to the tune of 1 crore, and responds are liable to compensate the same. Respondent the insurer alone contested the petition. In its respond number 3, in its pleadings admitted the issuance of the policy covering vehicle number AP27 AD 3636 And it was also admitted that respondent number 2 is a insured and respondent number 3 was a registered owner of the vehicle. However, I'm sorry, who was not holding the valid and effective driving license. The dependency of the claimants on the deceased was denied. It was further contended that the vehicle was a private car and the deceased had hired the same on rent. Thereby there was a breach of policy condition and respondent number 3 was not liable to compensate the damages. The tribunal, on raising the lesser issues, legal manager was examined as RW1 and exhibit R1 ಇನ್ನದು ಪಾಲಿಸಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಆ ಪಾಲಿಸಿ ಅಂತಾನೆ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ.
ಪಾಲಿಸಿ ಬರೆದಿದ್ದಾರೆ, ಪಾಲಿಸಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್.
It is not a policy. And
Schedule.
policy endorsement schedule was marked at exhibit R1. The tribunal, on hearing the parties, by the impugned award held that the accident and death of Ramesh Babu occurred due to the actionable negligence on the part of driver of the offending car. The tribunal, based on Aadhaar card, ಯಾವ್ದು ನೋಡಿ ಹೇಳಿದಾರಂತೆ, ಏಜ್ 57 is PAN card. Based on the PAN card of the deceased, considered his age as 57 years, assessed his income at 2,66,925 per annum. ಅದು per annum, deducted 1/3 from the same for the personal expense of the deceased, applied 9 multiplier, future prospects ಕೊಟ್ಟಿಲ್ಲ ನಾನು, and awarded compensation of rupees 48,04,650 on the head of loss of dependency. The tribunal in all awarded compensation of this 49. Respondent number 3, the insurer. Challenging the said award, the insurer has preferred MF number 2092 and the claimants, questioning the adequacy of the award, has filed MFA number 758 of 2022. Submissions of Sri Krishna Swami Lord's counsel for the insurer. Claimant number 1 and 2 cannot be considered as dependents of the deceased. The evidence of PW1 shows that she was working as teacher and she was working as teacher and earning rupees 22,000 per month. Both of them were living separately. Only the claimant number 2 was living separately from the father. Our evidence all ಹೇಳಿದ್ರಲ್ಲ.
Claimant number 2.
Claimant number 2 was living separately in her matrimonial home. Therefore, the tribunal committed error in considering them as considering both the claimants as dependents. The tribunal should have deducted half for the person, also 1 upon 2, the 50% of the income of the deceased for his personal expenses. The compensation awarded on all heads is on the higher side. The risk incurred by respondent number 1 is not one RC owner is not liable to be indemnified. More points. Reduction. ಏನದು citation ನೀವು ಹೇಳ್ತಿರೋದು? What is that citation ಏನೋ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ?
Manavalagham's case and also the decision of
The daughters are entitled
division bench of this
to compensation only on the head of
70 of 2020.
loss of estate and not on the head of loss of dependency. ಅವ್ರು ಕೊಟ್ಟಿದ್ದೆ ಈ ಮುಂದೆ ಒಂದು ಶೀಟ್ ಇದಲ್ಲ ಎರಡು in support of such submission he relies on the following judgment. The coordinate bench of this court. They are the baby and other sources. Shri Nagendra Kumar and another. DD 13/6/2023. Shri submissions of Shri Ravi Shankar, learned counsel for the claimants. So, claimants 1 and 2 are the married daughters. They had no income of their own. They were dependent on the deceased.